Welcome! During this video, you will learn how to start a parentage case in Santa Clara County, California. This is like a divorce, but for unmarried parents who want to establish that they are the parents of their children and want to request custody, visitation, or child support orders. This video will show you how to open a parentage case with the court and request a hearing to get those custody, visitation, or support orders. This is a self-help center, meaning that you represent yourself and are responsible for all the decisions in your case and for completing all of the necessary steps, which we will explain shortly. The center cannot provide advice or strategy. What we can provide is information about the parentage process in California and the choices you'll be making. The Self-Help Center is neutral, so if the other parent comes to the center, they will also receive help with their paperwork. Since you represent yourself, each time you come to court, you should be sure to 1. Bring copies of everything you filed or that is important to your case. 2. Bring a government-issued photo ID. 3. Understand the paperwork as you are filling it out before you sign it. And 4. Understand your next steps. Remember that the court will not move your case forward. You are responsible for your own progress. If you find that you need legal advice, you should speak to a private attorney. Our court takes domestic violence very seriously. We recognize that some cases, perhaps yours, may include issues of domestic violence, whether it takes the form of physical abuse, financial abuse, emotional or verbal abuse, controlling behaviors or threats regarding children and custody, or immigration issues. The moment of filing and serving court papers in any kind of proceeding can be one of the most dangerous points in an abusive or controlling relationship, and domestic violence victims are often unaware of that danger. We can help you seek the kind of help you may require to ensure your safety at this point and going forward. So do not hesitate to contact the Self-Help Center for assistance. Please be aware that the forms require that you list a mailing address. If you do not want the other party to know your address, then you can use a mailing address for a friend or family member. You can also list a P.O. box. It is okay to not use your own address as long as you can receive mail at the address you do list. While a mailing address is required, you are not required to list your phone number or email address. To set the expectations, this video will go over general information about court and provide you with legal information you need to think about when opening a parentage case. Then we will go over how to fill out the forms and your next steps for processing the forms and opening your case. Why open a parentage case? This virtual workshop and video is for you if you and your child's other parent have never been married to each other. Opening this case allows you to establish that you are your children's legal parents. When two people are married and have kids, they are automatically assumed to be the children's legal parents because they are married. For unmarried parents, this is the legal process that will officially determine that you are both the legal parents of your children. At the end, you will get a judgment establishing this. Most people open a parentage case because they need court orders to decide which parent has custody, the visitation schedule, and/or to determine child support. Some parents open a case for other reasons, such as getting a passport for their child. Parentage cases can take a while, and it will usually take many months to get your judgment and any of those orders. However, the court understands that most people cannot wait that long for custody, visitation, and support issues. So, in addition to opening your case, you have the option to request a hearing. The hearing will be scheduled about 1 to 2 months out and will allow you to request any child support, custody, or visitation orders for the immediate future. To request a hearing, you must file a form called a request for order. You can only file a request for order within an existing case, which is why you must also open the parentage case even if all you really need right now are the custody orders. This workshop will help you to prepare both the parentage forms and the request for order forms. So, if you follow the instructions, you will be filing both at the same time and will be given a hearing date when you file your paperwork. We'll talk more about this later. If you do not have an urgent need for orders from the court, or you simply want the court to establish parentage for your child, but do not need specific custody, parenting time, or child support orders, you might not need to file a request for order. These are some situations where requesting a hearing might not make sense for you. If your child's other parent lives outside the U.S., serving someone with legal forms if they are in a different country can be a long and complicated process. This means you would be unable to serve them before the hearing date, but a hearing cannot proceed if the other party has not been served on time. If you do not know where the other parent is, again, you will probably not be able to serve them on time if you need to track down the other parent and have no clues about their location. If you are not in contact but believe you could find them quickly and get them served on time, you may still want to consider requesting a hearing. If you and the other parent are living together, if both parents live together, the court will not make custody or visitation orders because it's too difficult to separate each person's time with the child if you are all in the same household. If you are not requesting a hearing, you should still continue with this workshop. We will explain later what you should do differently when filling out your forms. You also have the option to come back to court and request a hearing at any time in the future, before and even after your parentage judgment is entered. So, if you decide you don't need a hearing right now, but things change in the future, you can come back and request one at that time. If you are still unsure whether you need to file a request for order and schedule a court hearing, please contact the Self-Help Center by phone, email, or live chat. Parentage cases are also known as UPA cases, so you should be familiar with that term. Your case number will always start with the letters CP, which stands for Confidential Parentage. All parentage cases are confidential, so whenever you come to court or need help with your case, you must always bring a government-issued photo ID. If you have an emergency and the child is in danger, please contact the Self-Help Center as soon as you can, as this workshop does not handle emergency situations. It's important you let the court know that there is an emergency and you cannot wait the usual time of a couple of months to get court orders. If the judge agrees that your situation is urgent, they can issue temporary orders that go into effect about 1 to 2 days after you file the paperwork, and you will get a hearing scheduled sooner. However, you will need to prove to the court that there is an emergency and show that your child is in danger due to the other parent. If you fall into one of the following categories, it's really important that you contact the Self-Help Center before starting on your forms. Not handling these issues at the outset can sometimes cause serious problems down the road. If you fall into one of these categories, please contact us immediately and we can determine whether or not we can help you at our Self-Help Center, or if you need to get help from a private attorney. Furthermore, these issues are time sensitive. Please don't wait to resolve them. Sometimes, when too much time has passed, some of these issues cannot be legally resolved. These are some potential situations that will complicate your case. First, if someone other than the biological father signed the voluntary declaration of paternity, known as a VDOP, which is usually signed at the hospital or the birth certificate. In other words, if the person you are listing as your child's father today is a different person than the one who signed those documents at the child's birth. Second, if the mother was married to someone besides the child's biological father or had been divorced less than 300 days when this child was conceived or born. Third, if there is an existing judgment, perhaps from a child support case, that says someone other than the biological father is the legal father of the child. You do not want multiple legal documents that list two different men as the father for the same child. Fourth, if you signed the voluntary declaration of paternity and would like genetic testing to determine that you are not the child's parent, you have limited time to ask the court to order a genetic test. In most cases, after the child turns 2 years old and you have not taken the test, you become the legal father, even if you are not the biological father. Fifth, if the child was conceived outside California and the other parent doesn't live in California and never has. Sixth, if the child has not lived in California for the last 6 months, unless it's only because the child is less than 6 months old. Please note that you should open your parentage case in the county where the child lives. So you should only complete this workshop to file in Santa Clara County if your child lives in this county. It's okay if you yourself live in a different county, as long as the child lives here. Again, if your situation falls into any of these categories, please contact the Self-Help Center before proceeding with your forms or consult with a private attorney. Next, we'll go over the steps you'll take to open a parentage case. The first step is to watch this video. Next, you will have several options to choose from to complete your forms, either online or by hand. If you would like your forms to be reviewed by the Self-Help Center before filing them, you may submit them to our office through the link on the workshop website. Once your forms are ready, you will file them at the clerk's office located in the Family Justice Center courthouse, or you may be able to electronically submit them by e-filing. We will explain this process in detail later on. Please note that if you want the Self-Help Center to help with your forms, you will be required to complete a viewing verification of this video. This is how we can confirm that you have watched the entirety of the video before we assist you. Since you are the person starting the case, that makes you the petitioner. Your child's other parent is the respondent, since they can respond to the case you open. Once the case is opened, these terms remain the same forever. You will come across these terms many times in your forms, so it's important you understand them. The filing fee for starting a parentage case is $435. This is a one-time fee that you will pay once at the start of the case. If the other parent responds and participates in the case, they will also have to pay a $435 filing fee. If you also file a request for order, you will have to pay an additional fee. Every time you request a new court hearing, you will have to pay that fee again. If you can't afford the fees, you can request a fee waiver. You can apply for the waiver if you receive public assistance, if you qualify as low income, or if you can show the court that your income does not leave you with enough money after your expenses to pay the filing fee. You may ask the court to waive the fee entirely to allow you to make payments over time, or to give you a reduced fee. Be aware that if you don't make the payments as determined by the judge, your case won't be able to go forward and may be dismissed. If you choose to fill out the forms using the online program, it will ask you if you'd like to request a fee waiver and will provide you with that form. If instead you fill out the forms by hand, be sure to also request or download the fee waiver form. Standard restraining orders apply to every parentage case opened in California. These are not domestic violence protective orders, but rather restrictions preventing each parent from doing certain things. Neither parent is allowed to take the minor children out of the state of California or apply for a passport for the minors involved in this case. There may be an exception if a parent obtains prior written consent from the other parent or a court order granting special permission. As soon as you file your paperwork and open your case, these restrictions will go into effect for you. They go into effect for the other parent, the respondent, as soon as they have been served. They remain in effect until a judgment is entered in your case or the case is dismissed. This is a brief summary of those orders. Before filing your forms, you should read through them for more details because you are responsible for knowing and following them. If you have concerns about these restrictions, you may wish to seek legal advice from a private attorney. It is essential when filling in names on your forms that you list everyone's full legal names, including for the children. You must always use the same version and spelling of everyone's names on every form, today and every time you come to court in the future. If you or the other parent use any other names, you will need to include these on your documents when you fill them out. This does not refer to nicknames, but to different legal versions of your names that you may have used, such as on a driver's license, social security card, or immigration documents. You will put AKA for also known as and put the additional names down. For example, these are all different versions of the same name. Legally, these are all different people, so it's important to list each variation of the name as an AKA. For your minor children, you will need to make 3 decisions about legal custody, physical custody, and visitation, also called parenting time. If you choose not to request a hearing, you will need to wait longer to get court orders on these issues, but they will still be included in your final judgment, so you still need to make decisions about them. The first thing you'll need to decide is legal custody. This determines who will make important decisions for your children, such as where they will go to school and the type of medical care they receive. You have 3 options to choose from. You can ask that you make these decisions on your own, which would be sole legal custody to you. You can ask that the other parent make these decisions on their own, which would be sole legal custody to the other parent. Or you can ask that you make these decisions together, which would be joint legal custody to both of you. It's important to note that legal custody is what gives a parent the right to make decisions about the children. It does not force them to actually make them. The next thing to decide is physical custody, which is about where the children will live most of the time. Again, you have 3 choices. You will need to decide if they will live mainly with you, which would be sole physical custody to you, if they will live mainly with the other parent, which would be sole physical custody to the other parent, or if they will live partially with each of you, which would be joint physical custody to both of you. Physical and legal custody are 2 different things, so you do not need to choose the same type of custody arrangement for both. For example, you might choose sole physical custody for yourself and joint legal custody. This would mean the children live mainly with you, but you and the other parent make decisions for them together. Even if one parent has sole physical custody, in most situations, the court wants to see that the child is able to spend time with both parents. This means that the parent without physical custody is given some form of visitation. In order to do that, you'll have the opportunity to propose a parenting schedule, which is also called visitation, for when the children will be with each parent. Your schedule can be as strict or loose as you think is best to reduce conflict around your children. Even if you have a written schedule, it is okay for you and the other parent to agree to make minor changes to that schedule. But having a court-ordered schedule gives you a backup plan if you ever disagree. It's easier to have a clear and enforceable schedule from the start before conflicts come up. If you already know that it is very difficult to negotiate with the other parent, or that they may not follow your agreement, you'll want to make sure that your schedule is enforceable. That means that someone who has never spoken to you, like the police, can look at your schedule and figure out exactly where the kids are supposed to be at a given time. For example, 1 day a week or 3 weeks in the summer is not specific. Law enforcement won't know which day or which weeks, so they won't be able to enforce it. It would be better to say something specific, like every Wednesday from 4 p.m. to 8 p.m. Often, parents choose to alternate weekends, meaning they each have the kids every other weekend. However, saying alternate weekends in your court-ordered schedule is also unclear and unenforceable. Law enforcement won't go back months or years to try to figure out which weekend you started on in order to figure out whose weekend this one is. Even if you are just negotiating between yourselves without involving the police, alternate weekends can be problematic and confusing. Often, parents make agreements to exchange or rearrange weekends so that it's better for the children, but then later, when a disagreement arises, it is impossible for them to agree as to whose weekend it should be. The clearest schedule, if you're doing weekend visitations, is if you indicate that one of you will have the children on the first and third weekends of the month or on the second and fourth. Anyone can look at a calendar for any month and any year and figure out whose weekend it is and who the children should be with. Most of the time, this arrangement will be very similar to alternating weekends. Some months, although only 2 or 3 per year, will have a 5th weekend. You can specify who gets the children when a 5th weekend does come up, or you can leave it blank on your forms and assume that the custodial parent will keep the children on those weekends. If you and the other parent cannot come to an agreement regarding custody and parenting time, you will be required by the court to attend mediation before the court will make long-term orders. The goal of mediation is for you and the other parent to work with a child development expert to come to an agreement. Don't feel forced to make an agreement, however. You always have the right to say that you want the judge to make the decision after you've done your best at mediation. If you are scared for your children to be alone with their other parent, you can ask for no visitation or for supervised visitation, but it will be your responsibility to show the court why this limitation is necessary. If you request supervised visitation, you will need to decide between a professional supervisor, such as a court-approved agency, or a non-professional supervisor, such as a relative or friend whom you trust. The supervisor must be present throughout the entire visit. The court might grant supervised or no visitation if the other parent has been physically violent or has physically or sexually abused either your child or another child. You will want to bring the judge any evidence that you have of these things happening. The court might also grant this request if the other parent has a serious drug, alcohol, or mental health problem that's dangerous to the children. You need to show the judge that there is truly a connection between their problem and the safety of the children. For example, if someone is driving drunk with the children in the car, the judge can see that they are at risk of physical injury. But if they only drink when the children are not around, or they used to drink in the past, the judge may find it difficult to see how that puts the children at risk now. Something that is not grounds for supervised visitation is that the other parent doesn't care for the children the way you do. The court expects that the other parent might parent differently and can learn parenting skills like diaper changing, for example, if there's a need. As part of your parentage case, the court can order child support. Child support is for food, clothing, and shelter for your child. It does not include sports, private school, or vacations. To make support orders, the court will need financial information from your family. If you would like to request child support, be sure to file a request for order and request orders about support. If you already received child support from the other parent, please do not request it again on these forms. You should only request child support here if you do not already have a child support case opened with the Department of Child Support Services. If you have existing child support orders but would like to change the payment amount, please see the Self-Help Center website about modifying support orders. It's important to note that sometimes the state will open a child support case for your child without you being aware of it. If you've ever received CalWORKS, also known as cash aid, the state may have opened a child support case against the other parent to reimburse the state for the aid given to your child. If you think this may apply to you, please contact the Department of Child Support Services or the Self-Help Center to confirm you do not have an existing case before requesting child support orders on these forms. If you do ask for child support orders, you will need to provide some personal financial information. To determine child support, the court will take into account your income, the other parent's income, and the amount of time that each of you cares for the child, among other things. When you fill out your forms, you will be asked for the other parent's income. If you do not know this information, you will have to make a good guess. If you believe that they do not have any particular education or work history, one option would be to say that they are capable of making minimum wage. But for many people, that will not be a very accurate guess. You may be able to make a better estimate by recalling what they made when you were together. If you saw their paychecks or pay stubs, if they told you what they make, what they paid each month in expenses, or by doing some research online as to what people with similar backgrounds make at their jobs. Do not leave this blank, as the court will assign minimum wage to the other parent's income if their estimated income is 0. You will also need to provide information about your job, education history, income over the last 12 months, and your regular household expenses and bills. When you file your forms, you will need to attach proof of your income for the last 2 months. This means attaching copies of your pay stubs or other applicable proof of your income, either of public assistance or other benefits. The local child support agency offers free services to parents and guardians to help them meet their responsibilities to their children. These are some of the services they provide. They can help you establish paternity for your child with a court order and can help you arrange for genetic testing when the child's father is in question. They also provide some assistance in locating parents. Specifically, if you don't know where the non-custodial parent is located, the local child support agency will try to find the parent to establish paternity for the child's father and/or to establish, change, or enforce orders for child support. Once paternity is established, you can get help with getting a child support order based on each parent's income, timeshare, and other visitation. Most orders will also include a wage assignment, meaning that money will be withheld from the non-custodial parent's paycheck to pay child support. In certain situations, they can help you get a change in your court-ordered child support amount, which is called a modification. Your children have a right to health insurance coverage. They will work with you to make sure your children get the health insurance coverage they need if it is available at no cost or at a reasonable cost. The local child support agency has several ways to collect child support for your children, including withholding wages from paychecks, license suspensions, levies on property and bank accounts, and passport denials. Additionally, they can intercept other income and benefits, including state or federal income tax refunds, unemployment, workers' compensation, state disability benefits, and lottery winnings. Some of these enforcement actions are required by law. Others will be used depending on the facts of each case. California child support payments are collected and processed by the California State Disbursement Unit, or the SDU. Those receiving child support can choose to have payments deposited directly into a bank account or receive payments on an electronic payment card that can be used like a debit card. If you are making child support payments, you must consult with the local child support agency to confirm your eligibility to make child support payments electronically. If you request a hearing, you will need to write a declaration. This is a written statement where you will explain to the judge why you're asking for these particular court orders. Remember that the judge does not know you or your family, and you don't get much time on the day of the hearing. Your declaration is where you can explain to the judge the particulars of your situation and explain why this is the best possible arrangement for your children. It's important to note that the court will always prioritize the well-being of the children, so make sure to explain how your requests are in their best interest. Attach proof if applicable. For example, if you say your child is always late for school when the other parent has them, attach a calendar showing when your child is with the other parent and a school document showing which days your child was late. Also, if you are requesting no visitation or supervised visitation for the other parent, make sure you really explain why that is necessary in your declaration. We'll now go over the instructions you'll be following to open your case. Please note that there are some additional questions that the forms will ask that we haven't covered regarding additional expenses of pregnancy, attorney's fees, and children's name changes. If these do not apply to your situation, please feel free to leave them blank. Only fill them out if you need the court to make orders on that issue. Your first step is to complete this video. If you will be requesting the Self-Help Center's services to review your forms, you must complete the verification questions at the end of this video. Next, you will fill out your forms. You have a few different options for completing your forms. If you wish to fill them out online using an interactive program, you will use a website called Guide and File. The Guide and File program will ask you questions, fill in your information, and then produce your completed forms as PDFs, which you can download and print. If you want your forms reviewed by the Self-Help Center before you file them, you will send us those PDFs for review. Alternatively, if you do not want your forms reviewed, you can consider electronically filing them. Guide and File gives you the option to e-file your forms directly from the website. This means you open your case electronically and do not need to come to the clerk's office in person to file your forms. First, you will create an account on the Guide and File website. Make sure to save your login, username, and password, as you may need to log into your account later to make edits to your forms. Once you're signed in, you will be asked what type of case you'd like to open. Make sure to select Petition to Establish Parentage or Custody and Support. A few pages later, the program will ask you what type of petition you want to file. Make sure you select Petition to Determine Parental Relationship here. Do not choose Petition for Custody and Support of Minor Children, as this will open the wrong type of case. You will later be able to request custody and support orders within your parentage case. To make sure you fill out the request for order forms to request a hearing, you will want to select Yes when you get to this page. The program will then ask you to write your declaration, and when your forms are finished, the request for order will be included. If you do not want a hearing, select No on this page. If you would like to fill out the forms by hand, you can download the packet of parentage forms and a sample to guide you from the Self-Help Center website. You can find these forms on the Self-Help Center website by selecting Complete Forms at Home on the drop-down menu, which takes you to this page. You can then click on Self-Help Center form packets and samples. Under Starting a Parentage Case, you will be able to choose between just establishing parentage or establishing parentage and requesting a hearing. Once you download, print, and complete these forms, you can either take them directly to the clerk's office to file or scan them and submit them online to the Self-Help Center for review. Finally, if you do not have access to a computer, internet, or printer, please contact the Self-Help Center to request the blank forms. If you would like your forms reviewed once completed, please call the Self-Help Center to arrange a non-email review process. The Self-Help Center offers to review your forms before you file them. While this is an optional service, having your forms reviewed by our staff decreases the chances of errors in your forms. If your filed forms contain mistakes, you may have to amend them later, which can complicate your case. Please remember that we cannot give you legal advice. We only help ensure your forms are properly filled out. If your case is particularly complicated, we recommend getting your forms reviewed so a staff member can help you directly. To get your forms reviewed, please return to the Virtual Parentage Workshop page on the Self-Help Center website. There, you will find the Sign Up link to get your forms reviewed. You'll provide some personal information about your case, and upload the PDFs of your completed forms to this page. Once your request has been received by our office, the Self-Help Center will contact you about your next steps. Once your forms are completed, you will prepare to file them. If you used the Guide and File website to fill out your forms, you will have the option to electronically e-file them. Follow the site's instructions if you choose to do that. If you do not e-file, you will first need to print out your completed forms. Then you need to separate out some specific forms that do not need to be signed, photocopied, or filed just yet. You will notice that your printed set of forms includes some blank response forms. These are for the other parent to use to respond to the case you're opening. You should leave them blank and hold on to them, as these will need to be served on the other party later. The other form to leave aside at this stage is the proof of service, called the FL-115. Next, you will need to sign and date all of your remaining forms. Make sure you don't miss any places requiring a signature. Next, you will make 2 sets of photocopies of your forms. In total, you should end up with 3 sets of your forms, the originals plus the 2 photocopies. Each of these is necessary. You do not need to photocopy the blank response forms or the proof of service at this stage. Then you'll bring your forms, the originals and the copies, to the clerk's office. The clerk's office will take all 3 sets, file them, then return 2 of the sets of forms back to you. The court keeps the original set for itself. You will keep 1 copy for your records, and the last copy is for the other parent. If you're not asking to waive the court fees, you'll pay the filing fee then and get your file stamped forms back on the spot. If you are asking to waive the filing fees, you will submit your fee waiver to the clerk's office at this time. It may take about 24 hours to process the fee waiver and get your filed forms back. However, if you receive public assistance, your fee waiver should be approved immediately. The next thing that needs to happen is called service. The other parent needs to be served, which means they must be given a copy of your filed forms and the blank response forms. This step is very important. Your case cannot move forward until the other parent is served and made aware that you have opened a parentage case involving them. The timing is also very important. You'll then need to prove to the court that this was done properly. Not doing it properly will cause you many problems, so make sure you follow all the instructions carefully. Once your forms have been filed with the court, someone who is not you and who is over the age of 18 must serve the other parent. These are the documents they must be served with: a filed copy of all your court forms and the blank response forms for the other party. Once you have gathered together all the paperwork to be served on the other party, you are ready to have them served. It is okay for the server to be a friend or family member. You just can't do it yourself, and they must be over 18. If you don't feel it's safe for someone you know to serve them, or you don't want to involve anyone, you can hire a process server to serve the other parent. Process servers are professional servers and can be found online. They charge a fee for their services. Service means that the other party is directly hand-delivered the forms. This doesn't have to be a confrontational process. It is okay to call the other parent and ask them to meet your friend to be served. They do not have to agree to be served or sign anything. If the other parent refuses to take the papers, your friend needs to leave the papers at their feet and walk away. They are considered to have been served. If you are requesting a hearing, you must serve the other party at least 16 court days before the hearing date. When you file your forms, you will be given a date for your hearing. Then you must count backwards 16 court days to figure out your deadline. Court days are like business days and do not include weekends or court holidays. Whatever your deadline is, that's the date you have to get the other parent served by. If you don't serve them on time, the hearing will have to be rescheduled. If you find yourself unable to serve them on time, reach out to the Self-Help Center for assistance to ask the court for more time. If you are not requesting a hearing, there is no deadline for serving the other parent, but you should try to do it as soon as you can to avoid complications. The person who serves the other parent must sign a form called the proof of service. This tells the court that they handed the other parent your filed forms and details when and where the exchange happened. When you print out your forms or fill out the packet by hand, this form will be mostly blank. This was one of the forms you pulled aside earlier, so make sure that you do not accidentally file it when you file your initial forms. Instead, you will give this form to your server and they will complete and sign it after having served the other parent. Please remember that you do not fill out or sign this form. Only your server does. Once they've filled it out, your server will give the completed form back to you. You will make one copy of it, and then you will file both the original and the copy at the clerk's office. Errors on this form cause many of the problems we see for people who are trying to finish their cases, so make sure it is filled out extremely carefully. There is no cost for filing this form. There are some situations that may make service more complicated. In these cases, you should reach out to the Self-Help Center if you are unsure how to proceed, or let us know when we are reviewing your forms if you choose to use that service. Some examples include: if the other party is incarcerated, it is easy to serve them. You will just need to contact the prison or jail. Some facilities have a designated deputy who may serve your forms for you. Other facilities may require you to have your server give your forms to a deputy or jailer. If you need more help understanding this process, please contact the Self-Help Center. If you feel it's going to be impossible to serve the other parent, perhaps because you are not in contact and do not know where they are. If the other party lives in another country, depending on where they live, the rules around service may vary, and it's important to look up the specific requirements for your case. What happens next after service? If you filed a request for order, your next step is to go to your hearing. If you are unable to make it for some reason, make sure to request a new hearing date ahead of time. The Self-Help Center can help you with this. When you come to court, make sure to always bring a government-issued photo ID and any paperwork related to your case. If you did not request a hearing, your next steps are to wait for the other party to respond to your case. You must wait at least 30 days, during which time the other parent can decide whether or not to file a response. If they still have not filed a response after 30 days, you may proceed forward in the case without them. If they do respond, then you will both participate in the case together, moving forward to get your final parentage judgment. Don't stop there. Make sure to follow through to get a final judgment about who your child's parents are. The court will not move your case along for you. You must take the next steps. Most often, you and the other parent will agree you are both the child's parents, even if you don't agree about a parenting schedule or support. If you attend a hearing and if you both agree that you are the child's parents, the court attorney may be able to prepare the judgment forms. If the other parent disagrees that they are the child's parent or doesn't come to court, the court attorney will talk to you then about your options. Either way, you need to make sure you still get a judgment establishing your parentage. The case is not over just because you come to court once. Even after you get your parentage judgment, you can always come back to court to get new custody and parenting orders. Thank you for watching this video. We hope you have gained valuable information about starting a parentage case. Please see the Self-Help Center's virtual parentage workshop page for more information on the process. If you need additional assistance, please contact the Self-Help Center by phone, email, or live chat.